Your Honor, I am Vincent Placide, and I will make submission by way of a closing speech on behalf of my client, defendant, Mr. Wayne Pollock. Having taken on board what has been said throughout the trial, the examination in chief, the cross-examination, and the allegations that have been made in this case, I wish to make it clear that at all material times, my client was of the view that the alleged victim consented to his actions. Your Honor, we are at this point or this stage in the proceedings where we can look back and make an assessment and determine whether the allegations in this case have been proved, or in fact whether there has been any doubt surrounding the version of events as advanced by the victim, Carol Fox. Your Honor, the prosecution in this case has relied on 4 witnesses. Witness number 1's testimony can only be described as attesting to the appearance of the victim after the alleged incident. Mary Hutton, the victim's friend, stated that Carol Fox, and I quote, seemed really, really upset, like she had been crying. And she went on to state the victim's appearance. And she also advised that the victim that she would be informing the police. What then proceeded was for the identification of my client as being the one pointed out by Carol Fox as having perpetrated the offense or the alleged offense on her. Your Honor, I also hasten to add that no eyewitness or witnesses to the actual sexual assault has been put forward. Although you may say that in such cases where it is of a sexual nature, it is very difficult for one to have actually witnessed such an incident, except of course the victim, who of course being the one where the act is being perpetrated upon. Your Honor, there has been medical evidence advanced by the medical practitioner Valerie Singleton, who carried out an examination of the victim following the alleged attack. In her evidence, she states that both inner thighs showed the early stages of bruising, both breasts showed a pattern of redness and mild inflammation. And finally, noted as number 4 on her witness statement, it says that, and I quote, there was inflammation to the tissue around the entrance to the vagina. There was also a pattern of scratching to this area and to the tissue just inside the vagina. In my opinion, the injuries were consistent with the complaint made. However, in terms of the injuries themselves, the possibility of their having been caused by consensual, albeit robust sexual contact cannot be excluded. Now, Your Honor, these are the words, in her own words, of the medical practitioner Valerie Singleton. This is not me paraphrasing. What she said out in her statement, that in terms of the injuries, the possibility of these injuries having been caused by consensual, albeit robust sexual contact cannot be excluded. So, what the witness is actually, in fact, saying is that they could have been, those injuries could have been caused by consensual contact, by consensus between the two parties. However, having been a robust sexual activity, that such bruising and such inflammation could have happened. So this casts a lot of doubt, Your Honor, as to whether it is my client, whether my client forced himself upon the victim, or whether the client had in fact consented. If we cast our minds back to earlier on that evening, when Carol Fox and my client met, we know that they danced early in the evening. They had some contact in terms of dancing. We know that, or my client stated that Carol invited him to go out for some fresh air, to which he consented, and he went out. Of course, Carol would have said in her witness statement that he asked her to go out for some fresh air. And of course, by suggesting that he asked her, I would imagine that she might have known or believed in her mind what was to follow next. So if we were to go on what she was saying, then at the back of her mind, there must have been certain thoughts, which she actually, in her own testimony, states that she knew or expected something of what he might have been up to. Let us not get away from the facts, Your Honor. They are two consenting adults. My client, attaining the age of 23, Carol, who is 34. They both went down an alley next to a tire shop. They then proceeded to what Carol thought, or what she says she thought, was just a cuddle, but which progressed to other things. So based on that, Your Honor, and those events that led up to what we can now say is robust sexual activity, the victim then came back into the Ocean nightclub, expressing to her friend, or rather her friend noticing that she, not looking very happy, decided to ask her what happened. And then her reply was that she was messed about with by the young man that she had been dancing with. Let us look at the statement closely. She was messed about with. Your Honor, it is a very vague statement. It is devoid of any connotation of what she then went on to express to the police. Later on, after being examined, it was then found that she was probably forced himself on her, which is what the case is all about. Your Honor, I wish to say that my client, Mr. Wayne Pollock, is employed as a car mechanic by C.U. Wright Motor Engineers in Bulwell. He has been employed with them for the past 7 years. My client is of good character. My client, when at the time that he was arrested, he did not try to resist arrest. He cooperated with the police. He has had no previous convictions whatsoever. My client is, by all intents and purposes, a hard-working young man. Your Honor, I would like I wish to sway you, Your Honor, and I wish to put to you that the victim and my client engaged in these activities on a consensual basis, and that my client, based on the testimony that he had earlier, did not force himself on the client, on Carol Fox, but that they were both consented as two consenting adults. My client was of the view that she was happy, and my client only stopped going any further when he found that she then resisted. And for those reasons, Your Honor, I'll ask you to find my client not guilty. I thank you.